it's actually possible that the entirety of the crime could take place in the mind of another person. That's remarkable, isn't it?
Well, I'll try to find the section here now.
Sure.
But it is for the judge to make that decision.
I think it is the judge who makes, or perhaps the jury, who makes the decision whether it was bona fide perceived by the victim or another person. But they don't make the decision whether or not that perception is correct. They make the decision whether that perception was made.
This is Here's How, Ireland's political, social and current affairs podcast, presented by William Campbell.
Thank you for downloading episode 163 for the 10th of August, 2023. I heard Mark O'Halloran on an old episode of the Mario Rosenstock podcast recently. He talked very articulately about how the housing crisis affects him, how he, as a man in his 50s, has to ask someone's permission to get a pet cat. I totally sympathise with his position. Sometimes it's the small things like that which capture so well the dysfunction created by the housing crisis. I'm sure some left-wing party is writing up a bill as I speak called something like the Tenants' Right to Pets and Animal Companionship Act 2023. In fact, Sinn Féin is actually proposing a bill to make it illegal to ask for sex in return for a tenancy. That sounds horrific. I'm not convinced how widespread a problem it is, but if it even happens once, that's obviously unacceptable. But consider this. Do we have a problem of supermarket workers demanding sex in return for groceries? Is that even conceivable? In Ireland it's not, but in recent years there have been scandals of aid workers in both Somalia and Haiti in the midst of famine demanding sex for food. The conclusion is obvious. That can only happen where people are so desperate, be it for food or for housing, where people are so desperate that they are vulnerable to sexual exploitation. So it's particularly insane that we have some people, particularly on the left, saying we don't have a housing crisis, we have a renting crisis. We do. We have a housing crisis. And we get people, again primarily on the left, saying we can't build our way out of the housing crisis. Yes, we can. That's exactly what we need to do. We need to build. We need to build suitable homes in suitable locations, and we need to build them in vast numbers. If you really need it to be proven to you, you can look at the figures. Ireland has by far the lowest number of dwellings per 1,000 people in Western Europe. Those figures come from the OECD. And there's good reason to think that even those figures miss just how bad the situation in Ireland is. Those figures from the OECD are from 2020, but they only had access to Irish figures up to 2019. Now, to get the number of dwellings per capita, you obviously divide the number of dwellings by the number of people. But Ireland is the only Western European country with a sharply increasing population. So those figures from 4 years ago understate the current population. And as per the last two censuses, Ireland has hundreds of thousands of dwellings that are being left vacant for various reasons. So those figures significantly overstate the number of dwellings available to live in. Both of those factors, more people and fewer dwellings, indicate that the OECD figure, bad as it is, significantly understates the problem in Ireland. Another factor is that other Western European countries tend to have very settled, older, stable populations. Ireland, by contrast, is young, has a high birth rate, and has a high rate of both inward and outward migration, though the net figure is strongly inward, and has high internal migration. And for a variety of reasons, this means that there is more demand for housing. This is a bit complicated, but basically what happens is that if Johnny in Limerick leaves school and goes to get a job in Dublin, and Mary in Dublin does the same to Limerick, they don't really each want to stay in the bedroom in the parents' house that the other has left empty. So internal migration, which we have a lot of, that increases the need for accommodation even before you start talking about an increasing population. So Ireland is at the bottom of the OECD league table for the number of houses per capita. There's strong reason to believe that the true figure is much worse than the OECD figure. And unique features about Ireland mean that we need more, not less, housing per capita than our neighbours. This is not just theoretical. We have the OECD figures, but we also have just the raw number of dwellings completed from the CSO. That's basically the number of houses and flats built. There is a sharp uptick in 2022. It's not clear if that'll be maintained in 2023, but in each of 2019, 20 and 21, there were about 21,000 completions, and last year there was about 30,000. But unpublished research from the Housing Commission, reported in the Irish Times, says Ireland may need up to 62,000 homes built every year until 2050 to meet demand. So since 2019, there were 92,000 homes built in total, out of a total demand of 248,000. So that means 156,000 families are either living in substandard accommodation, shacking up with parents, homeless, or emigrating because there weren't enough homes built for them. That's a lot of figures to take in, but just to summarise it, over the past 4 years, 92,000 homes built, 156,000 needed but not built. And that's just in the last 4 years. We already had a very serious housing shortage in 2019. We are building less than half of what we need. So what solution are our politicians working on? Well, the government's Housing Commission are hard at work on a solution. That is, having a referendum to put the right to housing into the Constitution. It was reported recently that the work on this referendum is being held up by arguments between the members of the Commission, but I'm sure they'll get around to it eventually. But in principle, enshrining the right to housing into the Constitution, this is not a bad idea. It's not. It's an absolutely terrible idea. It sounds great, I know. It's exactly the sort of awful idea that sounds great until you actually think about it. There is a lobby group made up of various housing NGOs that are pushing to have the wording create a very broad and enforceable right to housing included in the Constitution. I'm sure that loads of you listening out there are among the hundreds of thousands whose life is ticking by, still living with your parents, who have visions of taking up a court case on the strength of this, and they imagine some beetroot-faced judge raising himself up on his knuckles and ordering that this injustice against a decent person be rectified by them being given a house by the minister, by the government, by someone. The fantasy gets a bit blurry after that point. But that's just not the way that courts work. The function of the courts is to adjudicate when people believe there is a conflict of rights. A conflict between society and the accused in a criminal trial, a conflict between two citizens in a civil case. The court assesses the facts and the law and comes down on one side or the other. The purpose of the law, and ultimately the Constitution, is to give the courts instructions on how to make that decision. Some cases are clear-cut, but those ones don't typically end up in court. To understand just how bad an idea this proposed referendum is, it's helpful to look at a previous referendum that was also inspired by an active and well-supported lobby group. The so-called Right to Life referendum was passed by a 2-to-1 majority in 1983. It was one sentence long. It said, The state acknowledges the right to life of the unborn and, with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practicable, by its laws to defend and vindicate that right. The lobbying came about because mostly religious groups saw that abortion had been legalized in the US by using a general privacy principle in the Constitution to stop state interference in abortion. And they were afraid that the same would happen in Ireland. The Attorney General at the time, Peter Sutherland, proposed a wording that said, "Nothing in this Constitution shall invalidate any law against abortion." That would have removed the risk of a similar ruling in Ireland. But religious influence in politics was in the ascendancy at the time, and they wanted to go further, not just have the Constitution not protect the right to abortion, but to have the Constitution outlaw abortion and do so in extravagant, flowery language, talking about vindicating rights, which fitted well with their religious outlook. The amendment didn't just say that you don't have a right to abortion. It said that the fetus had the right for the government to do everything to prevent you from having an abortion. And then they threw in that, of course, the mother has an equal right to life. Gee, thanks. That was their downfall. It wasn't long before their hubris collided with reality. In 1992, a young girl had been raped and was pregnant. Her parents took her to England to have an abortion, and they made inquiries about using a DNA sample as evidence against the rapist. Then, the full effect of the Eighth Amendment swung in. Remember, it didn't just prevent the courts from creating a right to abortion, it imposed a positive duty on the government to, as it said, vindicate the right to life of the unborn. The controversial new Attorney General, Harry Whelan, sought, and was granted, a High Court injunction basically ordering her and her parents back to Ireland before the abortion could be completed. Predictably, there was uproar. There was an avalanche of public opinion against this order in Ireland and huge, mostly hostile, media interests internationally. The case was appealed to the Supreme Court, and I happen to know that. This is not a huge secret. Lobbying is not supposed to happen in Supreme Court cases, and maybe it didn't work, but I am aware that people closely identified with conservative elements in the Catholic Church lobbied ferociously to find some way to allow the girl to have an abortion. They obviously calculated that, rightly I think, that the longer the case went on, the more it damaged their position. The Supreme Court, which hears constitutional appeals from High Court cases, had a bit of a problem if they wanted to reverse the ruling. It was this. The High Court ruling was well grounded in the Constitution. The Eighth Amendment didn't just say there was no right to abortion, it said that the state was bound to do everything it could to prevent abortion, regardless of the fact that a big section of public opinion was outraged by the effect of that, and even supporters of the Eighth Amendment wanted to make the case go away by any means possible. They searched hard, I have to give them that. The Supreme Court really had to search for it, but in the end, they found it. Remember, the amendment said that the state guarantees the right to life of the unborn with due regard to the equal right to life of the mother. And the young girl had said that the situation had left her suicidal, so her life was threatened by the pregnancy, and so that equal right to life of hers gave her, the young girl, a right to have an abortion. And not just her. I don't dispute her sincerity, but it gave every woman who could make the unfalsifiable claim that continuing a pregnancy made them suicidal, all of them now had a right to have an abortion. A few years back, we had Niamh Ivrian on the podcast. Niamh Ivrian, previously of Youth Defence, now of the Life Institute. Her mother was Una Ban Nikwahuna of wife-swapping sodomites fame, who was a major campaigner in favour of the Eighth Amendment. And Niamh Ivrian said that the ruling was perverse, that ruling from the Supreme Court. And I think she's right. But the irony of it was that the situation was created by the pro-life campaign's insistence on having that extravagant, flowery, ideological language talking about vindicating rights included in the Constitution, when they could have agreed to a much simpler and clearer wording. Such a wording would have left politicians to tweak the law so as not to create cases like this or the tragic death of Savita Halappanavar. The pro-life absolutists would not have liked that, but in the end, the outcome is that those cases, and the way they radicalise public opinion, have left Ireland with an abortion regime that is as liberal as most countries in Europe and more so than many American states. Their success in passing such an all-encompassing amendment led directly to the situation that they most wanted to prevent. And all of that detour is to illustrate one simple point. Don't put anything into law, especially don't put anything into the Constitution, unless its effect is totally clear, and in particular, don't put anything into the Constitution that is aspirational or guarantees to vindicate rights without saying exactly how that vindicating is going to be done. The Home for Good campaign is lobbying to have a constitutional amendment guaranteeing the right to housing, to have that added to the Constitution, and this is their proposed wording. The state recognises and shall vindicate the right of all persons to have access to adequate housing. Sounds great, but it's a terrible idea. Why? Because what effect will this have? Well, I can tell you one effect it won't have. That amendment will not build one extra house. It will not lay a single brick on top of another. One clear danger of this is that it doesn't say all citizens. It doesn't even say all residents of the state. It says all persons. So, say a pensioner who emigrated 40 years ago is coming back to Ireland to retire, and they have that right just as much as anyone else who lives in Ireland. But that's not my main objection. There is no way to word this amendment that doesn't bring the danger of unintended consequences. But what could happen? Well, in Ireland we have planning regulations, we have zoning, we have building codes, we have fire safety standards. And these aren't theoretical pie in the sky for law students to write philosophical PhDs about. These are real enforceable rules, and they mostly do get enforced, and they're enforced by people who are very professional, very careful, and very practical and pragmatic about making sure that the desired effect is achieved. We do have corruption in the system. To my knowledge, we have some serious cases of corruption, but that corruption is exclusively on the side of those regulations and codes not being enforced when they should. There are some countries where codes and regulations like this are weaponized by corrupt officials who demand bribes in order to approve things that they have no business blocking, but that does not happen in Ireland to any serious extent. If your planning permission request meets the zoning and building requirements, then you will be granted that request and you won't have to bribe anyone. That's not something that every country can boast. The problems in Ireland are of people being paid off to grant permission where they should not. I know that there are people out there, people who get a lot of media attention, who talk about zoning and planning permission as if it were somehow the cause of the housing crisis. That's nonsense. They're not. There are 70,000 unused planning permissions in the country. That's sites just lying idle with planning granted because the owner makes more money that way than by developing them. We have hundreds of thousands of houses worth of zoned land around Dublin, land zoned for housing, with nobody building anything on it. But despite those figures, we have regular commentators showing up in the media trying to tag their hobby horse onto the coverage of the housing crisis. These are basically rich people who want to make more money. They are trying to exploit the misery of people searching for a home to get rid of regulations that prevent them from getting even richer. That's what they're willing to do. So you can bet your posterior that if there crops up another opportunity for them to get rid of regulations that restrain their wealth, they will exploit it to the maximum. And it won't be a billionaire pulling up outside the forecourts in a Bentley. No. They will make sure that it's a media-friendly litigant with a hard case that evokes sympathy. Sympathy and a high-powered legal team may be paid for by the billionaire. And they could argue that, for example, all this planning law means that they can't build a house on their parents' family farm. Some nonsense about safety of an exit onto a main road. Something about imposing the cost of providing services for one-off houses on the rest of society. Something about preserving the beauty of the countryside. And the litigant and their high-powered legal team will say, yes, the government is making laws to protect the common good, but none of that other stuff is in the Constitution. Our client has no other home, and their right to adequate housing is written into the Constitution. And, at a stroke, that could blow a hole through our planning laws. Or our building regulations. Fire safety? Sure, we grew up long before all these regulations and we all lived to tell the tale. Survivorship bias, what's that? All we know is that this development would not be economic if we had to comply with all these rules, and none of them are in the Constitution, but our purchasers' right to have housing is written into the Constitution. And zoning. What's wrong with building the housing estate there? If they need a school, I'm sure someone will build it at some stage. It's not my problem that they all have to drive out the same boreen at 7:30 in the morning. What is this car dependency anyway? That's not in the Constitution. But the right to housing is. The fact is that this referendum and the campaign around it is very likely to soak up all of the political will and the NGO activism and just the energy behind the demand for reform in our society. And it will not lay one brick upon another. In a moment, we'll have the interview, but first I want to say thanks to all of our patrons on Patreon, especially to Glenn O'Sullivan, who signed up as a patron since the last podcast. I really appreciate everyone who donates on Patreon. We don't get any huge amount of money out of it, but it helps us with things like paying for web hosting and phone bills and that. Kevin and myself basically donate our time for free. And getting a new sponsor on Patreon, thanks Glenn, it's always a big boost of confidence and a morale booster. It lets us know that people are listening to the podcast. We make a big effort to cover things that are undercovered in the Irish media. You're more than welcome to listen for free, but if you think that you could do the same as Glenn and the other donors and throw in the price of a cup of coffee once or twice a month, there's details how to do that on the website and at the end of the show.
Do you agree? Do you disagree? Follow at Here's How Podcast on Twitter and like Here's How on Facebook for updates on each show's contents.
Senator Pauline O'Reilly is the Green Party spokesperson on education and higher education. She's also the Cathaoirleach of the Green Party, and I spoke to her on a bit of a ropey line. Apologies for that, but I think it's worth it to put up with that because the interview is important. Pauline has been instrumental in steering the Incitement to Violence and Hatred and Hate Offences Bill 2022 in the Seanad. It's already gone through the Dáil. The bill had been expected to pass the Seanad before the summer break, but following protests it was unexpectedly delayed until the autumn, and it's not entirely clear when it might become law, if at all. I began by asking Pauline if and when the bill is enacted, what will become illegal that is currently legal?
I mean, the main change here is that there will be aggravated, there'll be an aggravated charge for certain offences where there's hatred involved in that, and so there's and it's particularly around protected characteristics. So it's not hatred just generally for everyone. It's hatred on the basis of a protected characteristic. So that might be related to ethnicity or gender. for instance.
Mm-hmm. And that has existed in law already, and we have aggravation of some crimes. So for example, if I come along and kick in your front door, that's a crime that causes harm. I'd be likely to be convicted of that. But if I come along and kick in your front door because you're gay or because you're an immigrant, I'm likely to get a stiffer sentence. And as I understand it, the justification of that is that if I do that, for example, while I'm shouting homophobic or racist abuse, that causes more harm because it degrades your quality of life more than otherwise, and it could degrade the quality of life of other gay people or other immigrants or whatever in society, even if they haven't encountered the offender, that just wider threat. Am I right in thinking that's the basic reasoning behind having an enhanced sentencing for crimes that are motivated by hate?
That is the essence of it. Now, what already exists is a crime of hate speech. Mm-hmm. And so that part will continue in this bill. Mm-hmm. But there's, what's carved out is that if, for instance, you're doing it, you're engaging in hate speech because it's part of your art form. So, for instance, comedy, that is not a crime.
Okay.
And won't be a crime under this legislation.
Okay.
And the other thing that the bill points out is that you can still be offensive. Mm-hmm. Just generally, you can be offensive. You can still say really controversial things that maybe most people don't agree with. You can engage in any kind of debate. This is really directing hate through speech at individuals based on their characteristics.
Okay.
And
You'll be aware of a lot of this, and you're obviously a legislator now, Pauline, and I don't think you're a lawyer, and neither am I, but you'll have a higher familiarity with this than perhaps some of the listeners might have. And I just want to bring in one concept which, and I don't like using Latin, but it has a Latin name, mens rea, and it basically means guilty mind. And the example that's given is that, to use my previous example, if I kick in your front door, but the reason I kicked in your front door is because I was walking past your house and I saw through the window you being held at gunpoint by some masked men, and I kicked in the door to rescue you, then I'm not guilty of a crime because I didn't intend to commit a crime, even though I did exactly the same physical act that might otherwise have been a crime. And actually, even if I'm wrong, even if I look in the window and I see some hooded men who are holding you at gunpoint, but I don't notice that there are lights and cameras and it's a film set, and I kick in the door to rescue you, but I'm totally, totally wrong, you're not in danger at all, I'm still not guilty. And it's not the case, so it's an important distinction, it's not the case that I'm guilty but I'm being let off for extenuating circumstances. I'm legally not guilty of a crime because I didn't intend to commit a crime. I didn't have mens rea, a guilty mind. That's the case with most criminal law, isn't that right?
It's the case with most criminal law, yeah. Now, in relation to this piece of legislation, it's difficult to know what's in somebody's mind.
Always, in any case, yeah.
This legislation is not going to follow that path, I suppose. It's that you are negligent, that you're not taking proper precaution not to engage in hate speech, because it's actually quite difficult to prove what's in somebody's mind.
Yes.
And it could open a person up to, I suppose, a false charge, because a judge might be guessing at what's in the person's mind,
Yes, but the courts are experienced in dealing with this. So if I go into a bank with a shotgun and a bag with the word swag written on it, and I hand it to the teller and tell her to fill it up, I won't get very far if I say, oh, I didn't mean to steal any money, I just happened to have my shotgun and I just wanted to take out my own money from the bank. Nobody's going to take it. So, courts are entitled to make reasonable inferences with that. But I just want to put that together with one other concept, and obviously, as I say, you deal with legislation, and a lot of people don't necessarily, and I don't either, but I've been looking into this. And a lot of laws have a definitions section at the start, usually, and it says, in this law, the word X means, and it gives a very specific, precise definition. So, for example, in the Copyright Act 2000, that was brought in to cover copyright on the internet. Obviously, in that act, there's lots of references to computers, but the word computer is actually not defined in that act. And that was very deliberate. The reason for that was because we're well aware that computers are evolving fast. For example, smartphones would probably count as a computer under this act, even though they didn't exist at the time that it was put in place. So that gives kind of flexibility in the act. Is the word hate defined in the Criminal Justice Incitement to Violence or Hatred and Hate Offences Bill?
No, it's not. And that's the challenging part. I think I certainly find it challenging as well that there isn't a definition of hate. And we will be coming back to look at amendments in relation to the bill. Mm-hmm. But I suppose the explanation there is similar to the explanation that you've given around computers, because the idea, I suppose, of hate probably evolves, or what looks like hate, or what hate looks like, I should say, that does change over time. Now, it's important to remember that we have in Ireland what's called common law. And so the law isn't just made up of the legislation. The law is also made up of previous judgments in the courts. Mm-hmm. And so those decisions go to form part of what a judge takes into consideration. And hate is already in a lot of decisions, mm-hmm. because we have this hate speech legislation going back to the late 80s anyway. And so there is
I just want to give
those judgments.
Yeah, just to give the listeners that. So that has, the concept of hate has been there in law. I think 1989 that was brought in this mm-hmm. thing of, that we mentioned, offences can get an enhanced sentence if they're judged to be motivated by hate. And actually, and I've been looking at Garda.ie on their website, so this is not the law, but it's obviously going off what you were talking about there, the various judgments that have come through courts and so forth. And it is defined, this is obviously guidance for Gardaí when they would be charging or arresting people or whatever, and it says the motivation of hatred is any criminal offence which is perceived by the victim or any other person to, in whole or part, be motivated by hostility or prejudice based on actual or perceived age, disability, race, colour, nationality, ethnicity, religion, sexual orientation or gender. And the key point that I think is there is that it is which is perceived by the victim or any other person mm-hmm. to be motivated by hostility to any one of those groups. Can you see that there's an issue there that not only do you not require, you don't have to have the mens rea, the intention to commit a crime on the part of the person who might be charged. It's actually possible that the entirety of the crime could take place in the mind of another person. That's remarkable, isn't it?
Yes, and this bill does not include that. So it's quite clear in this bill that it's not.
Pauline, to be clear on that, you are right that that's not included in the law, but it's not excluded either. And where the courts have and the Gardaí have a tradition of defining hate like that, it's reasonable to expect that will continue unless somebody comes down with a big precedent-setting judgment that changes that.
Well, I'll try to find the section here now,
sure.
But it is for the judge to make that decision, as opposed to the person themselves mm-hmm. who is deciding that they feel that it's prejudice, it's motivated by prejudice. It's the judge that makes the decision.
Pauline, I think you might not be correct. I think it is the judge who makes, or perhaps the jury, who makes the decision whether it was bona fide perceived by the victim or another person. But they don't make the decision whether or not that perception is correct. They make the decision whether that perception was made. Do you understand the distinction?
I absolutely do understand the distinction, but I'm going to have to find the actual part here. It's my understanding that it is not in the mind of the person, but it's objective. And that's why, this piece around mens rea, or around, the intention, that was something that that stakeholders said that they didn't want in it, because they wanted something more objective.
Well, some stakeholders, I imagine.
Some stakeholders, absolutely. And look, I think that there has been a general criticism, particularly around that the definition of hatred not being in there. That's one mm-hmm. of the biggest issues, I think. And I can understand.
And to be fair,
that
it's still not. And it was actually quite a surprise that the bill didn't go through the Seanad before the summer recess. That was what was expected to happen. That may now, there's a chance, because it's been delayed, I suspect, because of blowback from the public or from sections of the public. But that was the intention. And reading it, there is no definition of hate, as I think we've agreed. And where the courts have already a settled definition of what hate is, it is reasonable to conclude that that's a definition that is likely to continue unless something remarkable happens or unless it is altered in law.
I think that what we heard from the minister when the minister was in the Seanad was that I don't imagine that there will be a definition forthcoming, and I think that the real reason for that is the AG's advice. Is what the minister has said, and the difficulties around putting in a definition, and that actually it's very constraining if you do that. And so
but the law is supposed to be constrained, isn't it?
Well, the law is supposed to be constrained, but as I pointed out, I mean, there's lots of instances where you don't have definitions of things because it does have to be taken into account, I suppose, the society at the point in time, the previous judgments. So, there wouldn't be that sense of common law if everything was laid down in legislation. There's an element in our law of having both, that you have legislation and also you have previous judgments.
Mm-hmm. Okay.
And I can only tell you, I mean, it's not my piece of legislation. I can only tell you what.
You're a member of the government. You're in a government party, so that might be a surprise for you. But in general terms of your career and so forth, but you are. Go ahead.
Yes, but you will have heard that people across government and opposition have various views on matters, and what I'm just being honest with you about what's in the legislation, what's not in the legislation, and I'm being honest with you about what the minister has said, what the AG has said. But obviously, because it's not my piece of legislation, I haven't spoken to the AG, so I can't tell you what the AG is saying, other than that that's what you're being.
Of course, yes, and
I think there is that. It is a concern when you don't have a definition of something. Absolutely.
Okay. I would say, and I want to move on for this, but I would say that, there are instances where not defining something is appropriate, such as allowing the use of the word computer to move as technology moves along, but where you have something which could be considered to be a crime where somebody did not otherwise have any good reason to think so, and then they end up at the sharp end of a prosecution, that has the potential to generate a significant injustice. But what I want to kind of move on to the practical element of this, and on this podcast we have covered the trans issue extensively, and I don't want to get into that. I don't want to bore the listeners to tears, so I don't want to cover that whole topic, but I want to look at one particular incident, and there have been a few incidents along these lines, but I have one clip that I will play. It regards a 16-year-old girl called Abigail Wheeler in Springfield, Illinois, and she was kicked off a YMCA swimming team because she had raised an objection to a trans woman, biological male, apparently presenting entirely as male, getting changed in her swimming changing room. I think it's worth noting that these competitive swimsuits are not like the regular sort of swimsuits you might wear to a beach. They're very tight. They're very inflexible. It can take 15 minutes to get into them. It takes a lot of contortions while you're completely naked. So it's obviously quite a vulnerable position for a young teenage girl to be in. And she objected to this. And I just want you to listen to this clip.
Me and one of my co-teammates, we decided we were going to put informative signs up in the women's locker room to let the members know kind of what was going on. And next day when we went to practice, my head coach told our girls team that there were hateful messages put up in the women's locker room that were considered hate speech and disrespectful. I then went to my coach and gladly told him that I was, a part of this, and he said that it was probably not the best option for me to swim with the swim team that night, and that the YMCA staff would follow up with my family.
Abigail, what did your sign say that the coach accused them of being hate speech?
Mine said 3 quotes. One was safe sport, women's rights, and biological women only.
And that's what the coach said was hate speech?
Yes.
Wow.
Okay, there's obviously a bunch of issues there, and I don't want to go into all of them, but I just want to focus on one specific issue in that example, in that girl told the interviewee she was explicitly told that she was being transphobic and hateful, and that her objection was hate speech. And regardless of all the other issues, regardless of what you think yourself about it, Pauline, what I think about it, do you think that it's reasonable to say that the person who was accusing her of hate speech was being sincere, that they genuinely perceived what she said as hate speech?
So, I mean, it's important to say that that's not a court of law. That's a decision of an organisation. So,
sure, no. I want to focus, Pauline. I want to focus exactly on what the person who was saying that thought or believed. Would you accept? And I think it's fairly obviously true that whether you agree with them or not, the person was sincere in saying it. They genuinely perceived it to be that way, even if it wasn't.
So this is to go back to this point about it is objective. It's not just what they think. So if I go to section 11 here, for the purposes of this part, any material or behaviour is not taken to incite violence or hatred against a person or a group of persons on account of their protected characteristics or any of those characteristics solely on the basis that the material or behaviour includes or involves discussion or criticism of matters relating to a protected characteristic. So this isn't about what the person perceives as hatred. Like it's objective here. The judge looks at this and the judge makes a determination that actually it involves discussion or criticism relating to protected characteristics. In that particular instance, it's to do with their gender. And
so this girl put up a poster.
It's saying that it's not incitement to violence or incitement or hatred.
So this girl put up a note in the locker room which said biological women only. It seems to me that looking at that Garda guidance as to what should and should not be considered hate motivation, that a person could well perceive that to be incitement to hatred.
But again, you're talking about perceiving when actually the legislation doesn't say that. The legislation specifically said it's not incitement to violence or hatred if a person is being, if there's discussion or criticism of their protected characteristics.
That doesn't seem to fall under either of those.
This is about what the judge believes falls inside or outside this act.
Pauline, I want to say on this, Pauline, I want to say on this for a moment, because if I put up a sign saying white people only, would that be protected?
Again, I believe from looking at section 11 that it's discussion or criticism related to their protected characteristic.
That doesn't seem to be either of those.
And I believe that that's what this is, in my estimation. But I think that it is the nub of why people are concerned.
Pauline, deal precisely with the question that if I put up a sign on any public facility or whatever that says white people only, or no black people allowed, or no Irish people allowed, or whatever, are you sure that that's protected?
I don't believe. I say that don't believe that it's part of this bill. However, for the reason that I pointed out, I think it falls under Section 11. However, it is still against the law.
Yeah.
Because it's against another law. And that law is about not being discriminated against on the basis of protected characteristics.
This is not.
So
Pauline, because I want to be very precise on this. This is not somebody who has the authority to enforce whether white people or black people or women or men or trans or whatever can go in. It's where a third party puts up a sign.
Yeah, but I am answering the question.
Oh, okay.
You just don't agree with my answer.
I'm looking at it, and it seems to me that the only working definition that we have is the one that the courts have arrived at, and that's in the perception, in the eye of the beholder, in the perception of the victim or another person. And I think you're kind of half conceding what I'm saying, that the bill has been put back in order perhaps to look at that again, but it probably will not get this mens rea test put into it. And it's difficult to say what else you could do. But the issue is that a reasonable person, even if we want to apply that test, could well perceive that.
It is not what they perceive. It is specifically said, this is not violence or hatred if it is discussion or criticism. So it's not what they think. It's actually objective, and it's the judge who gets to decide that, not the person who believes that what happened to them was hate. It's not that. And the second thing is, the example that you've given, maybe people want to do that, but it's against the law already.
No, it would be against the law for the person in charge to put up a sign like that. This was put up by a third party, by just a user of the facility, and there was no suggestion that this person was enforcing that. But I take your point, and I want to move on because I don't want to torture this to death. And to mention one of your colleagues in the Seanad, Senator Sharon Keoghan, a while back, she made remarks to a committee that she was on, and she made a remark about a witness before the committee, which the chairperson of the committee thought was not appropriate, and she asked Senator Keoghan to apologise to the witness, and Senator Keoghan refused. And then Senator Keoghan resigned from that committee, and in an email which he sent doing that, the subject line was unsafe working environment / resignation. And in the email, just to quote her directly, says, "I no longer feel safe or protected as a member of the committee and have made this difficult decision," that's to say to resign. "I've made this difficult decision as a result of that." It's worth noting that Leinster House is probably the most secure and safe location in the country. Would you accept, Pauline, that there's an awful lot of people kind of cropping up recently saying that everything that they don't agree with makes them unsafe, and this has just become a trend where people, are essentially making the word meaningless?
Well, yeah, I mean, that's why I suppose you need legislation, and that's where it comes down to the determination of somebody else as to what that is. And I don't know the full details of that committee, but there are rules about behaviour.
Yeah, she had made a disparaging remark about a witness.
Legislation, it's the same thing for legislation. There are rules about how we engage with each other.
Sure, but I'm asking you here about wider society and trends in wider society rather than specifically the legislation. There is kind of a trend out there of people basically who are on the losing side of an argument, and they, rather than trying to answer, they make a cheap shot to smear their opponents, and basically they're saying, you have to stop winning the argument, otherwise you're guilty of being a horrible person. That's what's going on there, isn't it?
Well, I'm not going to make some broad sweeping statement. There are people who engage in offensive behaviour, and that's why I think that it is important that it's in the legislation.
You're right. I agree. There are people who engage in offensive behaviour, but there are also people who engage in performance.
That's not covered by this law.
No, that's true. That's true. But there are people who engage in performative being offended as well, aren't there?
I'm sure there are. Of course there are. I mean, there have been for decades and for forever people who will act offended. But that's why it was really important in this legislation that this isn't about being offended. You can offend people. You can be insulting, and you can say anything you like about disagreeing with general characteristics. You could even say something like, well, I don't believe that there's any such thing as homosexuality. You can do all of that. It's not a crime, and it's specifically outlined in this bill that it's not a crime. And that's why I think it is important to do that, so that you don't have this situation where it is that people just can't be offensive. And that's an entirely different thing, though, than hate. And, I give the example of if somebody was to spray graffiti outside somebody's house, and it says something about their, I hate
this group. Yeah, we don't need to quote it. Yeah,
such and such,
yes.
because they are black.
Yeah.
then that's clearly hate. And that's
Yeah.
a different thing to, I just generally don't believe that there's anything other than two genders. That's entirely different. And that's why the legislation is specific around that and saying that you can still offend.
Okay.
And that you can engage in robust debate, and all of those things are not covered in the bill. And I think if you didn't have that in the bill, I think that actually you're probably more likely to get people accusing people of, just generally being offensive. I mean, it's not a crime to be offensive.
Okay, it is correct. It's not a crime to be offensive, and there is a quotation about that I may come to in a moment. But aside from those, and I don't think that I agree with you fully, but aside from those specific readings of the law and of case law that you are taking there is a wider societal effect of this. And I think we have to, be aware of the environment that this is going into. And to be honest, I think when Sharon Keoghan said that thing about she feels unsafe on the committee, she was trolling people and she was echoing language that is used by people who are normally on the opposite side to her. And there is a trend of people using the word unsafe to the point of one particular university professor being accused of genocide purely because of what she was teaching in her classes, with a very long and complex and very doubtful chain of causation, in my opinion. And you and I could disagree about the exact, way in which speech, including offensive speech, would be immune from that. But that doesn't change the fact that you can quite often get odd judicial decisions and decisions that go well beyond the law. I note that in recent days, we had a whole slew of cases for people not paying their TV license being dismissed by a judge who was disgusted by the shenanigans and corruption going on in RTE. So, the tone can be set by legislation and things can go beyond that. And your colleague, another colleague of yours in the Shannon, Michael McDonough, pointed out that this law would allow people to make a citizen's arrest because of the way this interacts with some other laws. There are some political and social debates that generate demonstrations that are incredibly bitter. Do you think it's really a good idea, whether they're correct in law or not? Do you think it's really a good idea to give anybody any excuse at all to create a situation which could be very messy and turn out violent, whereby somebody tries to arrest somebody else because they didn't like what they said at a demonstration?
Yeah, so there is, there are people who don't believe there should be any laws at all, and that they shouldn't have any restrictions on what they do at all. And that actually impacts on other people and their freedoms. And ultimately, you do have to say, well, either you agree that people need to be protected, and actually it overall gives people more freedom to have those protections in place, or you make a decision that it's just, a free-for-all, and that anybody can do anything in terms of make any decision they like about like not offering somebody a job because they don't like the colour of their skin and so on and so forth. You can say, well, that's completely their opinion and they should be allowed to do that if they want. But actually we have laws that say, no, actually you can't just make any decision you like when it impacts somebody else. And that's exactly what this legislation is about as well. And there are those who are going to say that it comes down on the side of those who want more protection, and there are those going to be saying no, it doesn't go far enough. But ultimately, in legislation, you have to look at it and try to take a balanced approach. And I believe that that's what it's doing. I think it's giving people more freedom, because if anybody is allowed to engage in hate speech based on somebody's protected characteristics, then those people are at risk. And I don't think that that's how most people want to live.
Senator Pauline O'Reilly, Green Party spokesperson on education and higher education, thank you very much for talking to me.
Thanks, William.
Never miss a show. Follow at Here's How Podcast on Twitter and like Here's How on Facebook for updates on each show's contents.
I have to say, I made a mistake there. In the interview, I said that neither me nor Pauline were lawyers, but Pauline was so polite. She was too polite to even say that she is a lawyer, so apologies for that mistake. But she said also in there that there's no danger that this bill will curtail freedom of speech. Kevin, are you convinced of that?
Well, William, I am not a lawyer, but I'm recalling when Pauline said that Section 11 was a defence of freedom of speech. Mm-hmm. I'm not convinced, because having looked at Section 11, there is a dangerous word, I think, in there, and that word is solely.
You, Kevin, you have to be the youngest boomer in town, because you sent me a photograph on a WhatsApp message of a screenshot of having taken a photograph of your computer screen. So I've got Section 11 up here, and it's a bit complicated, but just what it says is, I'll give the full text first. It says, for the purposes of this part, any material or behaviour that is not taken to incite violence or hatred against a person or a group or persons on account of their protected characteristics or any of those characteristics solely on the basis that material or behaviour includes or involves discussion or criticism of matters relating to a protected characteristic. So just to try and put that in slightly more understandable English, it's saying that it's not to be considered as incitement to hatred under the Act a discussion that is solely for a discussion or criticism of matters relating to a protected characteristic. So if a protected characteristic was, let's say, being a traveller, and you were discussing, for example, the low educational achievements of travellers, which unfortunately is the case, you, in theory, under that Act, could not be held liable for insulting or inciting hatred to travellers. But the word solely in there, so, I think you might be right, because, one bad joke that you might crack in a 100-page academic paper could potentially mean that the paper is not solely discussion or criticism of that. Is that what you're thinking?
There is that, but just also the possibility that that it could be argued, for example, in the case of the girls who were putting up the signs in the dressing rooms, that they were not solely engaging in a discussion, that they were that their actions had some additional effect as well, or they were doing something else alongside just talking about the trans rights in the bathrooms, for example.
Yeah. So if there's an argument that it is less than 100% covered by that, then it is subject to prosecution. But I also think that some people, when they think about somebody being prosecuted in court, they get a vision of some 20-something Gurrier who's got 150 convictions for burglary already and doesn't, the court doesn't, like, going to court is not something that would disturb them at all. But if this was the case of, somebody who had no experience of the courts and no experience of being at the sharp end of the law, just the threat of the process would be very, very intimidating for them.
Yes, no, I absolutely agree. I remember recalling Pauline saying that a judge would be very objective in interpreting the law, and you would not be in any danger if your speech was of a particular kind. But, like, I don't want to be in front of a judge at all. That is consequences enough. I think that is quite scary. So, yeah, I could definitely see that this legislation would have an intimidating effect.
Yeah, we covered on the podcast previously, somebody was instructed in, I think, the University of Bristol not to take part in particular research because the results might be politically incorrect. So being told by your university authorities not to do something is one thing, but that, I think, has a potentially very chilling effect, that if the threat is, don't do this research because you might end up in court even if you're guaranteed to be acquitted. There are some people out there whose lives are so pathetic that they spend basically their entire time searching for offence and making complaints. That chilling effect, even if you don't get a single conviction. I mean, you work in a university. How many researchers there do you think would be happy enough to be dragged through court as long as they were acquitted in the end?
Well, speaking for myself, I certainly wouldn't be happy to be that far along in a kind of legal process, and I don't think anybody else in the department would be either. So yeah, I don't think that the idea that you'd be vindicated at the end is very comforting for anyone.
Go to the website for sources and references from the show.
And while you're there, you can like the show on Facebook.
Follow the show on Twitter at Here's How Podcast.
And follow Pauline O'Reilly at Pauline Galway.
Get in touch if you want to suggest a guest or a topic for a future show.
And thanks again to all of the patrons on Patreon, especially Glenn O'Sullivan. It covers the costs of keeping the podcast going, and if you can throw in the price of a cornetto,
or even the price of a bottle of Factor 50 once or twice a month, please do go and sign up at patreon.com/here's how.
That link is on the website. Also there you can find out how to subscribe to the podcast for free.
On your computer, on your phone, or by email.
All of that information is at www.here'show.ie.
The Here's How podcast is produced and presented by me, William Campbell.
And the co-producer is me, Kevin Wolf. Thank you for listening.